All persons having business for the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save this United States in this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. We have one case on this morning's calendar, Keith LittlePage versus United States. And counsel, you may proceed.
Good morning, Richard Seligman on behalf of appellant Keith LittlePage. The issue before the court is the denial of the appellant's rights under the Innocent Protection Act to obtain DNA testing pre-trial, which is what I would like to focus on here today, of materials that were potentially exculpatory. I believe that the court applied the wrong standard in applying the post-conviction standard and determining the production, and that the DNA comparison with CODIS was available pre-conviction by showing under Rule 16 that it was material to preparation of defense. And the SOC in particular, which was at issue, was found very close to the body of the decedent, and therefore it was relevant in the fact that the police seized it and at the time of their investigation showed it was a relevant portion of their investigation and their belief that it potentially had evidentiary value. So the argument is that under the Rule 16 and the CODIS, which allowed for court order to order a comparison, would have provided the defendant, in this case, the opportunity to determine whether the SOC was somehow related to the perpetrator, or that the SOC contained evidence of a witness, which would have led to information about the perpetrator. In either event, the failure to, it was found by the court that the failure to advise the defendant of his rights under the Innocent Protection Act was that really the first prong of ineffective assistance of counsel, that it was deficient performance, and that we would argue that the second prong, which was that he was prejudiced by that, applies to both the ultimate obtaining of the comparison under CODIS, but it also pertains to just the ability to use the SOC and the failure of the government's analyzing it as an argument in showing the court did not, the police did not thoroughly investigate this case and led to reasonable doubt under the circumstances. This was not an overwhelming case. The DNA, there was no DNA evidence connecting, or any other scientific evidence connecting the defendant with the offense. There was no eyewitnesses, no murder weapon was found, and the defendant had no history of violence between him and the victim. The evidence was he merely, she merely told her mother that he was getting on her nerves. The motive, which was focused on in this, that she gave him AIDS, sort of is interesting because he apparently knew, along with others for years that she had AIDS, HIV/AIDS, and that was never an apparent issue previously.
Mr. Seligman, could you remind me of what argument counsel did make about the government not having adequately investigated the case or police not having thoroughly investigated? Wasn't there some argument to that effect?
There was some argument about that, and there was some pointing to, as was pointed out by Pelley in their brief, there was some argument about the fingernail scrapings, which were not analyzed. And so this would have provided additional fuel to that argument.
Was there an
Mr.
argument
Seligman?
made about items not tested? No?
I believe there was.
But did the government have a response to the reason for not testing the fingernail scrapings?
I don't recall a specific response to that. They may have. I don't recall.
I think I remember at least reading the briefs, and I just don't recall right now whether it was explained to the jury that it was because there was no signs of a struggle.
Well, I think the defense argued otherwise.
No, what I'm saying is that reason for not testing the fingernail scrapings would not have applied, for example, to not testing the sock that was found on the next to the body or close to it.
Well, I think that would be correct, Your Honor.
Now, you mentioned that you started out by mentioning the IPA.
Correct.
Right? But then you went to Rule 16 and CODIS. Can you draw the connection between those? I mean, do we look to the IPA and the language of the IPA to see whether there is a basis there for the request for a comparison with the CODIS database?
Well, I think the IPA, at least on the pre-trial provision, which is what we're addressing now, is very broad and allows the defense to seek DNA comparison of evidence that was seized at the crime scene. And this was not just any evidence. They talked about 87 pieces of evidence, but this was something that was right next to the decedent. And ultimately, once it was tested, showed that it didn't have the decedent's DNA on it, nor the appellant's.
Well, my question was, you're absolutely right that it talks about testing. The government seems to draw a distinction between testing and comparing the results of testing with the results of other tests in the CODIS system.
I think it's a logical progression. Certainly, had the police officers investigating the case felt that this would have been helpful to them, would have been able to submit this to CODIS for testing. The requirement, as long as the requirements in terms of the DNA analysis done locally met the criteria, and they thought that it might be related to the putative perpetrator in their judgment. So, does that answer your question?
I guess I'm also looking for maybe like a limiting principle here. Right? And maybe this is what you're talking about, that they thought it was relevant because they picked up the sock, the police picked up the sock. But is it, I mean, again, in terms of statutory interpretation, the statute gives you a right to have items tested. Would that also give the defendant a right to have every item that is tested and that shows DNA that is not the defendant's or the decedent's, I guess, to be compared with the CODIS database?
I think logic probably would compel that it has to have some reasonable relationship to what would be something that would be material to the preparation of defense, and that's where we get. I sort of shift over to Rule 16.
So if it's material to the preparation of the defense, and in this case,
Which is I'm sorry.
and you've identified two ways, basically a Winfield type defense and the failure to do a thorough investigation type defense.
Right. Tied to a situation where there was very little scientific or eyewitness evidence. Yes. I would submit that the CODIS 2.2 regulation is the regulation issue here, which has a sort of a different standard for court ordering the analysis, and it provides for any court, state court, to order it as long as it meets certain basic criteria. And the one that I think is particularly relevant here would be the evidence being analyzed was obtained in connection with the investigation or prosecution of the federal state offense. So that clearly this meets that standard, and the court could order under that standard as long as it complied with the testing parameters that for loading it onto CODIS.
That's for loading it on, but there was also something about a manual search, which doesn't, I take it, require the uploading onto the
Right.
system.
So as I understand the manual searches, frankly, my representations in the brief were largely based on the case that was cited in terms of the manual search, and that seemed to provide an alternative means for doing so. As I read the arguments throughout, the government threw up as many barriers as it could to prohibit the analysis under CODIS, and I think it's so we were pointing out that there was also the availability under this other provision. Subsequently, the regulations that are in place and in there, I think it's Section 5, which deals with that, appear to make it for a more limited purpose. I'm not clear in terms of the regulatory history whether that existed, that provision existed at the time this case was tried, because I was only able to get the 2019 version, and I would not. So I couldn't respond. So I'm not relying on that as a principle at this point.
I'm sorry,
I'm not relying on Section 5 as being a way.
Oh.
I think the appropriate section really is Section 2.2.
And so does this right or this authority maybe in the trial court to use discretion to order a comparison? I don't.
Yes.
Does it? I'm trying to, and I'm sorry if I'm just missing the connection here. Please help me. Is this under the IPA? Is this kind of a standalone claim under the CODIS regulation? Do we read the IPA provisions in the light of what CODIS of the NDIS operational procedures manual? I mean, they seem to me to be different things.
There's no question that they are different things. I'm not suggesting, but I think there is an implicit relationship in terms of the right to testing. And the fact that CODIS is in fact a governmental entity which has this information available to it. Under one of the arguments the government made under Rule 16 and the trial court made is that discovery doesn't include the right to have testing and it was that make evidence. And I would like to respond to that and say that this is not making evidence. This is just analyzing the evidence that was there, that was seized by the police. And it was under, I think, the government's control in the sense that it's the FBI and CODIS is another investigative agency that works with the District of Columbia. And so that is something that is available. It's under the control in that sense of the District of Columbia, at least through a court order.
But are you also making the argument under the IPA, just so that I can keep it straight in my own mind, that testing under the IPA isn't just testing for DNA of that particular item, the sock in this case, but that a further step in the analysis of that testing of DNA is the comparison part?
Well, the comparison part is clearly there even in the initial testing if they have something else to compare it to. So they're comparing it to the item to the blood or other DNA from the victim and or the suspected perpetrator. In this case, it's possible perpetrator or witness that would be provide a material, it would assist in the preparation of the defense. So that's a Rule 16. So I think they're tied together is what I'm trying to.
So the DNA testing is itself a process of comparison with a very large database. And you're saying the CODIS is just a further step going to a kind of a somewhat smaller database.
No, I'd say it's the other way around. It's the other way around, but I think that's the same. Yeah, the CODIS is a large database maintained by the FBI to determine whether identify individuals with felonies who have been or in that database and match that to an unknown set of DNA that the DC police acquired through an item of evidence on the crime scene.
So the initial testing does not involve any comparisons. It's just a biolog, whatever it is. You look at stuff under a microscope, I guess.
Well, it does involve a comparison. It can in there. I think it's specifically in the regulations. It's comparison to the either the victim or the suspect.
Okay, so there's already some comparison. That's right, because Mr. LittlePage was excluded and the decedent was excluded. So there was some comparison done as part of that testing. And you're saying it's a logical next step to.
Right. The government has the ability to take that next step if they wanted to. And under the, at least under that regulation 2.2, I think that was, the standard was different than what was applied in this case by the court.
Thank you.
And we submit that, analyzing this under the ineffective assistance claim, there was prejudice under the circumstances, and that the defendant need not show that the deficient conduct more likely than not altered the outcome of the case, but rather counsel's errors were sufficient to undermine confidence. And we submit that is the case here and ask the court to rule.
Mr. Seligman, before you sit down, may I ask you to begin with?
I laugh because I'm sitting down.
May I ask you a factual question about the evidence at trial? Do I understand correctly that on the night that the victim was, that Miss Knight was murdered, Mr. LittlePage went to Baltimore to stay with his cousin or friend.
I believe that's correct, Your Honor.
And is it correct that that the friend reported testified at trial that Mr. LittlePage told him he was at Knight's apartment that very night between about 7:30 and 8:30?
I know that he told him he was at the apartment. I don't recall the exact timing, but if that's in the record, I'm sure it's correct, Your Honor.
Okay, well, I have a question about the record, and that's why I'm asking you this. Is it correct that Mr. LittlePage denied to his cousin that he had killed Miss Knight that night? In other words, that night when he was in Baltimore with his cousin, is it correct that he told his cousin he denied having killed Miss Knight?
I believe that's in the record, and that was the cousin's testimony.
Okay, and is it also correct that the next day, I think it is, although it might have been that night, I'm not sure where, she can tell me, he spoke with his sister, and his sister asked him, according to the evidence at trial, has anything happened? Has something happened? And he responded, I didn't do anything to Miss Knight. Is that correct?
Yes, I believe that's correct.
At those times, had it been revealed that Miss Knight had been killed?
I don't know, Your Honor.
How would he have known that Miss Knight had been killed at that time, or that there was a question of whether anybody had killed Miss Knight?
I don't have an answer to that.
Okay. Now, with regard to Rule 16, to the extent Rule 16 is being invoked here, what section of Rule 16 specifically do you rely on?
Relying on, I think it's section E. Section E.
What does that say?
Okay. It says, that says, one moment. Says documents, objects upon defendant's request, the government must permit the defendant to inspect and to copy or photograph books, copies, documents, data, photographs, tangible objects, buildings or places, or copies or portions of any of these items. If the item is within the government's possession, custody, or control, and the item is material to preparation of defense.
I'm sorry, go ahead.
I think that's the portion of it that I'm addressing.
And what do you understand material to the preparation of the defense to mean in that context?
I understand it to mean anything that would reasonably assist the defense in their investigation and or presentation of evidence at trial, which would tend to assist them, and doesn't have to be purely exculpatory. It can be broader than that.
And what portion of that language do you think relates specifically to a comparison that the government has not performed between the biological material recovered from the scene and CODIS information?
Well, I think I misspoke. I think F, which deals with the examination and tests, this all deals with the tests and that the government has.
If the government had made the test,
correct,
done the examination, it would be within that language, right?
Correct.
But what if the government has not made the test or done the examination and has no intention of doing so either?
Well, the defense, I think, would be authorized to do the tests themselves under the IPA. And in conjunction with this,
Where does the IPA say that the, well, I'm sorry, I don't mean to cut you off. Please finish your sentence.
so I think the IPA says they can do their own independent testing. And it was given the choice of
being the defendant.
correct, and that they could also request, I think, the government to do the testing under their using the governmental entity that does the DNA testing.
Does the IPA define what it means by testing a biological material?
Yes, it does.
What's the definition?
Well, I think that was addressed in, I guess it was the Hood case, and but the definition since then, I believe, has been broadened. Would include material of this nature that might contain biological evidence, including clothing. So that the SOC would, I believe, under the current version of the IPA would qualify.
I assume I'll accept that assumption. What kind of testing is the IPA talking about? Does it say?
It talks about doing a DNA analysis.
Does it say anything about comparing the results of that analysis with with a database of DNA or anything comparable?
No.
And I take it that are you relying on in this appeal still on a Brady argument?
I think yes, but I think the standard is different in a Brady situation post conviction. So that would be we've addressed that, I think, in our brief, and I'm not abandoning that, but I'm focusing instead for purposes of this oral argument on the pre-trial analysis.
I take it that
and the ineffective assistance claim.
Okay, all right, good, thank you. I'm having trouble with feedback here. We'll give you a few minutes for rebuttal. Let us hear from Ms. Gabriel for the government.
Thank you.
Good morning, and may it please the court. Elizabeth Gabriel on behalf of the United States. The trial court did not plainly err here in failing to sua sponte order a manual keyboard search. I want to start out by setting the framework for the argument. Appellant tries to escape the materiality standard of the post-conviction IPA provision by arguing that the pretrial standard should apply. This case is now in a post-conviction posture, and we submit that the post-conviction standard should apply, including the materiality standard. Second, I want to note that appellant's brief challenges the trial court's failure to order a manual keyboard search under Section 5 of the NDIS manual. Now, at oral argument, he suggests that he's not relying on that, and that instead he's challenging the court's failure to order an upload of DNA under Section 2.2 of the NDIS manual. That was not a claim that he briefed, and we believe that it's been abandoned. The IPA does not authorize the relief that appellant sought here. The IPA authorizes DNA testing of biological material in certain circumstances. Here, the trial court ordered DNA testing on every piece of evidence appellant had selected, and nothing more was required. The The IPA does not mention CODIS, even though CODIS was in effect at the time the IPA was enacted, does not allow or provide a remedy by allowing a comparison or requiring a comparison of information in CODIS. And that's not surprising, because the purpose of the DNA Identification Act was to facilitate law enforcement exchange of DNA identification information. And that's the title of the federal statute. So the IPA doesn't provide the relief that appellant sought here. Rule 16 also does not provide the relief that he sought. To qualify under Rule 16, the appellant had to show not only that the government possessed the evidence, which we don't believe was the case, but also that it was material. And materiality here has to be viewed in the post-conviction context, because this is a claim under the IPA. So it would have to be material to help establish his actual innocence. He hasn't shown that here. The random sock that was found on the floor of the decedent's apartment hasn't been shown in any way to be connected to the murder. An appellant proffered no evidence to suggest that it belonged to the perpetrator or was or had any nexus to the crime. Because he could not establish materiality under either the IPA or Rule 16, we submit he wasn't entitled to any more than he had already gotten.
You began, Ms. Gabriel, by saying that the trial court did not plainly err, suggesting that we're arguing about something that wasn't presented to the trial court. What were you referring to?
Well, in the trial court, appellant never requested a manual keyboard search. He requested that the unknown profiles be uploaded into CODIS. Now on appeal, in his brief, he argues that it was the manual keyboard search that should have been requested, but that was never raised before the trial court. And because of that, it should only be reviewed for plain error. They are two different processes, and the NDIS manual has different standards for each of those processes. Of course, appellant has not met those standards in this case. He cannot show that the unknown profiles meet the standards for a manual keyboard search, because there were neither exigent circumstances nor any evidence in the record showing that the profiles had the minimum number of loci which would qualify for a manual keyboard search. And as the manual points out, that very special process is to be used only in the most urgent of circumstances where there's a public safety concern. So he can't meet those standards. Again, because he hasn't shown, bottom line, he hasn't shown any materiality, any reason to believe that the sock was connected to the crime. And that's essentially what we're talking about here, is a single sock, because we know that the three other items of evidence that came back with unknown profiles were things that were found among appellant's belongings in Daryl White's apartment. So without any connection to the crime, he simply wasn't entitled to any more than he had gotten. And we submit that the IPA doesn't provide a vehicle for the CODIS comparison that he was requesting.
Ms. Gabriel, if I may, you said that because these claims came up post-conviction, we need to look at this under a post-conviction standard. I guess you mean under the IPA in terms of what the but it's an ineffective assistance of counsel claim, which puts you, and the claim is that pretrial defendant was not advised, as he should have been, by his counsel and by the court, by the way. And the court recognized that he should have done so. In fact, he said he was shocked to find out he hadn't done so, of the right to test, right?
Yes.
So the question is, had the testing been done at the time, what would a good defense counsel been able to do with that evidence, right? Of a third party on a sock, you referred to as a random sock, but it was a sock that was, how close to the body was it when the police found it and seized it as evidence at the crime scene?
I don't have a precise distance. I know that it was found in front of the sofa where the victim
her
was found.
body was, right?
Yes.
I mean, if we were talking about DNA on a doorknob or, you know, things that people who might just come into the apartment might touch, a sock, you know, people, at least in my experience, don't usually go around leaving a sock, one sock out close to a dead body every day of the week. The police obviously thought it might have something, you know, it could be of interest. It certainly is of interest to the defendant because it does not have his DNA on it. It does not have the decedent's DNA on it. It has somebody else's DNA on it. So if you're a defense counsel, you think, wow, that's certainly interesting and something that I would definitely want to follow up on, even if the government is not interested. And he might be able to, defense counsel might be able to make, you know, the argument that, you know, it's third party perpetrator evidence, a Winfield type of defense, or if not, the defense that was made to a point, but not as good an extent, that the government just did not investigate this as thoroughly as it could have and perhaps as it should have, and not focused immediately on Mr. LittlePage. I mean, we know what that defense is. It is made, it is not an unusual defense. And when you can actually point to something very specific that could have been followed up on and wasn't, the defense, I think, carries more weight, might be more persuasive to a jury. So that's why I kind of question your mentioning, well, we only look at this through this post-conviction IPA testing lens, because that's not what the 23-110 ineffective assistance of counsel claim, which is the one that appellant's counsel has been emphasizing here today, is relying on primarily.
Right. Well, first of all, under Strickland, appellant still has to establish that there was prejudice. In other words, a reasonable probability of a different outcome, or a reason to believe that the evidence would have undermined confidence in the outcome. Right. And so there is a prejudice requirement. And you know, I think the fact that the police, first of all, the fact that they recovered the sock doesn't necessarily give it any added relevance. And the police scooped up 88 items of evidence, including a lot of things from the apartment that had nothing to do with the murder. And we have to keep in mind as well that the decedent's apartment had been ransacked earlier that day, in the early morning hours of the day of the murder. So, you know, it's very well possible that there were sort of random items of clothing on the floor. In any event, the defendant here, appellant here, did argue to the jury that the government had done a sloppy investigation, had failed to test items that appeared to be even more probative: fingernail clippings, cigarette butts, things that appeared to be, could have been more probative of the perpetrator's identity than a sock on the floor. And the jury rejected those arguments.
Did the government have a response to that? I know that I thought I read in the brief something about, well, we didn't look at the fingernail clippings because there was no sign of a struggle.
Right. That was the testimony of the defense witness, the crime scene officer. Of course, the defense pointed out that that there was a defensive wound found on the victim's arm, so that undercut that.
Yeah, but there was an argument. I mean, there was an explanation given. What would the explanation be for the sock?
I can only assume that it would be because the sock didn't appear to have any connection to the crime. That there was
other than its location and the fact that it didn't belong to either of the decedent or the defendant. I mean, that's a connection. I mean,
Well, may I ask a question about that? Do I recall, you mentioned this earlier, Ms. Gabriel, that the apartment had been ransacked. Do I recall correctly that things had been thrown around all over the place? Her clothing had been moved and so on and so forth. And do I recall as well that among the people who came over I think it was the morning correct me if I'm wrong, of the day on which Miss Knight was killed was her sister. And her sister went over with her to help her clean up the mess, essentially. Do I recall that correctly? And they discovered there was even more mess because he had come twice. Do I remember that correctly?
Well, I think the testimony was that the decedent's nephew and his girlfriend had come over to help her clean up. And then,
Girlfriend, okay.
yes, but the victim's sister did go to the apartment. She's the one who discovered the victim's body on the sofa. So they had all been in that apartment before the police went in and recovered the evidence. So any one of them could have touched the sock. And you know, the sock in this case is
And explain
very
why
much
the sock is where it is.
right. And I think the sock here is very much like those ordinary items that the court noted in Hood, which could have been touched by at any time and had no apparent connection to the crime.
May I ask you another question? Oh, go ahead. I'm sorry.
No, go ahead, Your Honor. Go ahead.
I was going to change the subject, so if you wanted to say something more, okay.
Sorry, I just did want to add one tail thought, which just sort of closed that loop, which is that there was no reason to believe that had defense counsel been able to present to the jury evidence that there was an unknown DNA profile in the sock, that would have strengthened his argument that that there was reasonable doubt because the government's investigation was inadequate. And given the very overwhelming evidence of Helen's guilt in this case, there's just no reason to believe that there would have been a different outcome.
Yeah, the question I wanted to ask you, it picks up on something Judge Ruiz was asking. The sock obviously was not in and of itself an incriminating item. Suppose though, we weren't talking about a sock in this case. Suppose we were talking about a knife. Now let's make this easy. That the defendant had said, you know, I want that tested. You didn't test that knife the first time around. And they find an unknown person's DNA on the knife. You could load this up as much as you want. If you want a little flecks of blood on the knife, you can put that. Suppose the defendant then says, okay, well, that's very interesting. And it's not my DNA, and it's not the victim's DNA. It's a woman's DNA on that knife. I would like it tested. Judge ordered the government to compare, or further test it. I would like the government to compare that with the biggest database we have to see if we can identify the biggest database the government has, to see if we can identify who that person is. Do you think the court could order it under those circumstances?
So under those circumstances, it sounds to me like the defendant might have been able to meet the materiality standard. But the IPA still doesn't provide that sort of relief. The IPA specifically allows a defendant to have biological material tested. It says nothing about notice or comparisons. Now, the NBIS manual contemplates a court order for an upload of evidence, but for an upload of a profile, but I don't see what the source of authority would be for the trial court in that instance.
You know, Mr. Seligman was suggesting, though, that there's almost a comparison aspect entailed in testing. It doesn't help anybody for there to be testing of material, and you just get back a profile and you say, okay, here it is. Here's the profile. And the next question is, well, whose is it? I mean, did you match it to anybody? Did you compare it to the defendant or anybody else involved in the case? So the whole notion of testing involves some comparison, doesn't it? And so why draw a line with respect to this large database, even though the IPA does not specifically doesn't mention CODIS at all?
Well, I wouldn't agree that that it's sort of a right with them or without a remedy. I think that the IPA, the testing that the IPA allows does provide and could arm a defendant with evidence to show reasonable doubt and to argue that somebody else must have done it because it wasn't him. And that's a very powerful argument to be made. Now, the comparison, I think if any comparison, any right to comparison could be read into the IPA, I think it would have to be comparison to the defendant or the victim, because those are the specimens that the IPA speaks of. But there's certainly nothing in the IPA that that makes clear that a defendant is entitled to a comparison to other individuals. I think, at the time, as I said, that the CODIS was in existence, and there's no reason to read into the IPA a form of relief that the legislature didn't make explicit.
So how is it, Ms. Gabriel, then, that we came to know that the DNA on the sock was not the decedent's and was not the defendant's?
It was compared to the DNA of the defendant and the decedent.
By the government?
By Sorensen, I believe.
By Sorens, by the private lab retained by the defendant?
Yes.
So the government itself did not do that?
No, I don't believe so.
Would not have done that?
Well, did not have a reason to do it in this case because the sock didn't have an apparent connection to the crime. There were, over 80 pieces of evidence collected, and the government had to make a decision about what items of evidence might be relevant to the crime, and did test those items that seemed to have a connection to the crime, or might have had a connection to the crime. Things that could have been, for example, the murder weapon. But no, the government did not test every single piece of evidence collected.
No, I'm talking about the comparison, not just as Judge Thompson said. The testing just tells you this is the biological profile of the DNA. And the question is, okay, what's the next step? So was there any comparison of the DNA of any of the items that were tested that was made by the government to see whether they included or excluded the defendant or the decedent?
Yes, I believe on the 4 items that were initially tested pre-trial, that came back with DNA profiles. I believe those were compared to the DNA of the decedent and appellant as well.
I have to say that knowing that there is this CODIS database, I'll call it that, I don't know what you call it. It's like this treasure trove of information, right? That we have this notion at times of a trial as a search for the truth, right? And of governmental obligations as having to do with fundamental fairness to the defendant. And we should all be concerned and care about whether or not the correct person is being charged and prosecuted for a crime, right?
Absolutely.
And so you get the sense, I get the sense, I have to say, and I understand that there should be some guidelines, that the government could just say, well, and now I'm talking about Rule 16 and Brady, primarily, not necessarily exactly what the IPA provides for or doesn't. That you can say, well, you know what? I just don't want to think about this. I just don't want to test it. And so therefore, I have nothing to give you. I'm not even sure I buy that argument, frankly, because CODIS is information within the control of the government, right? What, the database?
Yes.
Yes. And when we think about these obligations of the government is one entity, right? Composed of, we ascribe what each component entity knows to the whole. Is that correct?
Yes.
Okay, so in this sense, the government would be, let's say it's a prosecutor in the case. So the prosecutor in the case is holding 2 pieces of information in her or his brain. One information is a biological profile of the DNA found on the sock, right? Another piece of information, data point, in the prosecutor's brain is the information in CODIS. Does that, and And you know what? And if you put those two together, those two pieces of information together, the prosecutor not only knows that the piece of DNA, that the DNA on the sock does not belong to the defendant or the decedent, but in fact knows that that DNA belongs to somebody on the CODIS database, maybe even knows that that person resides in the District of Columbia. Maybe there's even more information about that person. I don't know. I don't know what else there is in CODIS, frankly. So why is that not information in the possession and control of the government that would be exculpatory and disclosable under Brady and Rule 16 to the defendant?
Well, I agree that if the government had that information, had done testing and had tested the sock and found that there was an unknown profile, that that information would likely need to be disclosed. But
wait, that did happen. No, the government did. I mean, there was testing of the sock.
Only
of the DNA.
Only post-trial by the defense. The government did not test the sock initially. So once the defense tested the sock post-trial pursuant to the court's order under the IPA.
But the government has that information, right?
The government did not have the DNA profile that was produced by Sorensen until it was produced by the defense. So appellant was asking the government to take information that he had and to run an analysis to produce evidence that
did the government have
information that the government had.
Did the government have reason? I'm sorry, I interrupted you. Yeah. Did the government have reason to doubt the testing done by Sorensen?
Well, I don't know. I think, in this case, Sorensen was not an accredited lab at that point. So that might have been reason, but I don't suggest that there was a reason to doubt the reliability of the testing. But
so the government had that information post conviction. Is there a Brady obligation post conviction?
Certainly, if appellant could show that it would be favorable to the defense, he would have to meet the materiality standard. And and here there was no way he could show materiality.
No. I'm assuming. Remember what my hypothetical is the prosecutor then post conviction knows what's on the sock, knows what's in CODIS, puts the two together, and bingo.
Well, I think that this case is very much like Bellinger in that respect. In Bellinger post-trial, the defense claimed that the government should have performed a ballistics analysis to compare a weapon used in the defendant's crime with a weapon that had been used in a previous crime. And the court held that the government had no obligation to perform that analysis to produce evidence that might have been exculpatory. If the government had already possessed that evidence and knew that it was exculpatory, then it would be different. But in this case, very much like in Bellinger, the defendant is asking the government to take evidence that he has and to perform an analysis to determine whether it would have been exculpatory. And he speculates, of course, that it would be exculpatory because he has no other evidence to show that the stock was connected to the crime.
But once the testing is done, the government has the information, whether or not it has tested it. And that would have been the same thing pre-trial if counsel and the trial court had done their jobs, right?
I guess I disagree with the premise. I think that the government has the records in CODIS, but appellant is not just asking for the CODIS records. He's asking for the government to take evidence that he has and to perform an analysis on it, to do a comparison, to determine whether it's exculpatory. And I don't think it's the same as in a case where the government possesses information in its files that that defendant simply wants production of. I think it is like Bellinger, it is like Malloy, where the court has found that the government doesn't have to perform a test to decide or to produce evidence that might be exculpatory.
This is not a test. This is information that already exists.
Well, it's an analysis is required. It requires taking the evidence that the defendant has, which was produced by Sorensen, and then performing an analysis on it. But in any event, even I do want to bring it back to the bottom line here that appellant simply showed no nexus between the sock and the murder. There was no connection whatsoever beyond his pure speculation that it might have shown a third-party perpetrator, but that was based on a chain of inferences that he would ask the jury to make. That the sock, the person who had touched the sock had some relationship with the decedent, had a motive to murder the decedent, and had an opportunity to do so. And without any further...
Well, had an opportunity for sure, because left the sock next to the body, right?
I guess one could argue that that's the case, but there would be, the appellant had no other evidence to point to suggest that that unknown female had any reason to kill the decedent or any connection to the decedent, any beef with the decedent, for example. So I don't think he has met the materiality standard either under the IPA or under Rule 16. He simply cannot get there. All right, if there are no other questions, we would ask this court to affirm the judgment of the Superior Court.
Thank you, Mr. Seligman. We'll give you 3 minutes for rebuttal.
Okay, thank you. Just briefly, to the last point, I think the issue is the government controls CODIS. CODIS has information that conceivably could be helpful to the defense. And there's no way the defense can utilize that, but the government can relatively freely do so. And I think in reference to Judge Ruiz's comments, that information is there. It may well be exculpatory information. We don't know until
How would this work, Mr. Seligman? How would this work? Let's suppose that the government agrees to do the test, the comparison testing you're suggesting, and finds a hit. So it finds that Jane Doe, a person in the CODIS database, has a DNA match with the DNA in the sock. And presumably one could find out, oh, Jane Doe was not in prison at that time. Jane Doe was living in Washington, D.C. She might have been a friend. She might have been a neighbor. She might have been, maybe we could show some connection between Jane Doe and the victim, maybe not. And then what?
Well, as postulated, I think in our brief, that one of the theories was there was a wide range of possible perpetrators if, in fact, the motive was anger over having transmitted HIV to that person. And the connection might...
Well, this is all speculative. I'm waiting to hear how this would actually be.
Well,
because right now, there's no materiality at all. There's no reasonable probability that what you know now, or even what you would know if the things I have described had turned out to be the case. There'd be no reasonable probability that that would have changed the jury's verdict.
When this is pre-trial,
it would require a great deal of further investigation, and the facts would have to be what right now you can only speculate them to be.
Well, we can only speculate now because we don't have that information.
Right,
If they
but,
had- if
but
they-
to the extent
I-
that one doesn't one in deciding whether or not you even have a colorable claim to have the government be required to do this, there has to be some threshold that would have to be met of plausibility and probability of a useful outcome. Because otherwise, the government would be inundated with thousands and thousands and thousands of requests to compare every piece of physical evidence found anywhere near a crime scene with the CODIS database. And this is a particularly difficult problem for you, it seems to me, because you can't really point to any particular clear statutory or constitutional requirement for this. So that's why I'm just probing as to see how this would actually work in practice if you were allowed to do this.
Well, I think the liberty interest embedded in and recognized in the IPA, I think this court has recognized there's a liberty interest there.
Can the judge take,
testing.
can the judge take into account the strength of the government's evidence against the defendant?
Well, again, we're talking about pretrial. See, the emphasis I'm making is pretrial. You're in this situation.
I don't
There's
think that's
time.
true. I don't think that's exactly right. Under the, or at least not the way we normally think of Strickland or Brady. We're asking, is there a reasonable probability that the outcome would have been different?
Well, you're talking about the prejudice analysis. Well, I understand that, and I've argued that there is under these circumstances, and particularly as to the first type of use of it, clearly would have been useful to undermine the government's case. But as to whether it pointed to a third party, there'd have to be more investigation, clearly, of an item that was found adjacent to the decedent that's unexplained. And that might,
Given that
investigations all the time.
Given that her house was ransacked twice in burglaries that were apparently committed by Mr. LittlePage, I have a little trouble viewing the sock's presence in the living room floor as completely unexplained, frankly. But
I would respectfully suggest that the evidence wasn't, there was no determinate finding that Mr. LittlePage was the one who did the ransacking. And the other side of that is if it was somebody else's, I think the argument about the sock not being relevant was that the place was ransacked. So I disagree, Your Honor, respectfully.
okay.
I don't have anything further to add if there's any other questions.
Okay, counsel, thank you both. The case is now submitted. We can allow each of you to log off.
Thank you.
Thank you.